you include the wrong things in your will, you can accidentally force your family into probate court, trigger tax issues, or even invalidate your plan entirely. My name is JP Rankin. I'm the owner-attorney of Rankin Law Firm, and I'm licensed as an attorney in California, North Carolina, and South Carolina. In my tenure as an attorney, I've helped hundreds of families avoid probate court, set up an estate plan and a legacy that they're proud of and they know will work when they need it to. In this video, I'm going to walk you through 8 things you should never put in your will and what you should do instead. Number 1, jointly owned property. If you own your house or bank account jointly with someone, your spouse, for example, it doesn't matter what your will says. In North Carolina and in South Carolina, that jointly owned property is going to be controlled by the title. The title says what happens when you pass away. Regardless of what you want to happen, it is going to be the controlling document. So if you own it jointly with rights of survivorship, then the person you own it with gets it as soon as you die, even if you wanted it to go to somebody else. Retirement accounts, such as 401ks, IRAs, those pass directly to the beneficiary on file, no matter who that person is, not through the will. Naming someone in the will could even cause confusion or future litigation. If your IRA has your previous spouse listed as the beneficiary, but your will has the IRA going to your children, unfortunately, that IRA is going to go to your previous spouse, and that's why it's so important to have your beneficiary designations accurate and reflect your most recent wishes. Here's a mistake that people make sometimes: naming a minor in a will or for an IRA. It creates a custodial account for that minor, and you're going to have an actual person managing their money until they become an adult, and that person might not actually have their best interests at heart. Number 3, life insurance proceeds. Again, beneficiary designation wins. Your will does not control the proceeds unless no one's listed or the estate is named as a beneficiary, which happens pretty frequently. What that means is if no one's listed as a beneficiary, it's going to pay out to your estate, and that estate, unfortunately, is going to have to go through probate, and it may or may not reflect what is written in your will. So the better option is to name a trust or an individual that is not a minor and never have it default to your estate, or you're going to probate no matter what. The 4th thing to avoid putting in a will is property that's already in a living trust. So if you took the time to create a revocable living trust and you also took the time to deed over that property to the trust, don't list those assets in your will because you're creating a conflict unnecessarily, and you're possibly putting those assets back into your estate, and then they go through probate, which is what you were intending to avoid in the revocable living will altogether. What you should do is put all of the property into the revocable trust and then have a corresponding pour-over will that will catch everything that's in your estate and then pour that over into your revocable living trust that's been properly funded. Funeral instructions, number 5. Most people don't read the will until after the funeral, and that makes a lot of sense. Why would you read it beforehand? So if you've got specific instructions on how you want your funeral or your burial to go, put that in your estate plan separately. You don't want to put it into your will because then it won't actually get executed the way that you want it to be executed, or even give it to your family now. There is a number of funeral directives and burial plats that you can purchase beforehand, and it's a negotiated contract that will affect as soon as you die. Those are some good options on how to avoid some confusion on what you want to happen with your funeral outside of putting it in your will. Conditions that violate public policy. You cannot put those things in your will because you cannot say, my son only gets this money if he divorces his current wife, or if my daughter marries outside of the family religion. Courts in North Carolina and South Carolina will strike that down. The important thing to think is you cannot put something in your will that will force someone to do something that is outside of public policy. You can, however, put limitations on when they will receive their money based on age or behavior. You can get as creative as you want. You just can't force someone to do something outside of public policy. Number 7, Medicaid or SSI relevant gifts to disabled beneficiaries. You do not want to put that in a will because leaving assets outright to a disabled child can destroy their Medicaid eligibility. In both North Carolina and South Carolina, that can mean a total loss of benefits. So instead, what you want to create is a supplemental needs trust where all of the money that you wanted to give to them can go, and it will sit for the benefit of that disabled child, and it will not affect their benefits that they're currently receiving. Digital assets without access instructions should not be included included in your will. If you run a business or store photos online, your executor or personal representative in South Carolina may never get access unless you have separate login instructions or use a digital asset clause. You may include this in your durable power of attorney, your pour-over will, and in your revocable living trust to ensure there's always a person that can access those accounts. Your will is powerful, but only if used correctly. Putting the wrong thing in it is like trying to fix plumbing with a hammer. You need the right tool for the right job. If you're in North Carolina and South Carolina and want your plan reviewed the right way, click the link below. We offer free consultations and planning sessions to make sure your legacy stays protected.